Hi, this is Stephanie Miller from The Stephanie Miller Show. Please enjoy this exclusive clip from my show on Political Voices Network. Barb, this is one of those times when we all need you guys desperately to explain how this could be possible to us. This ruling that Trump engaged in insurrection and yet still can remain on the ballot under this interpretation of the 14th Amendment. Can you explain your first take on what happened here?
Yeah, I didn't see this coming. I actually thought she would find just the opposite way. So there's sort of two questions that she decided here. Of course, the 14th Amendment, Section 3 says that, if you took an oath to serve as a federal officer and then you engage in insurrection, you can't serve as a federal officer again. And so the big question to me is whether Donald Trump had, quote, engaged in insurrection. Of course, as his lawyer argued, it's not like he was there with a pitchfork physically engaging, but what the judge found is it was sufficient. The rhetoric, the failure to act during the 187 minutes when all of this chaos was going on at the Capitol, and he could have stopped it. He gave aid and comfort. So she finds that he did indeed engage in insurrection. And I thought, there we go, we're done. Right. But what she found instead was on that definition of federal officer, that a president is not a federal officer, that federal officers are executive branch agency heads and others elected officials below the president. And so the president himself does not count under her legal definition of federal officer. So we are off to the Court of Appeals.
Well, Barb, okay, two questions. First of all, what does this mean for Jack Smith and the J6 case? Can he use this? I mean, this is what the J6 trial is going to be about, isn't it?
Yeah, this really doesn't affect that at all. It's a separate proceeding, separate findings, not binding on any jury in the federal or the state of Georgia case at all. And in fact, Jack Smith did not go so far as charging insurrection. Although now that we see the judge have found it, maybe he'd reconsider and consider adding that. It is the language, and the judge recently ruled in the Jack Smith federal election case that denying Donald Trump's motion to strike all of the language about the attack on the Capitol. They had argued since there's no insurrection charge, all of that is irrelevant. But what Jack Smith says is we have not charged the former president with inciting insurrection, but all of that is relevant to his intent. He was trying to use it and exploit all that chaos because he continued to pressure lawmakers, even after the attack on January 6th, to vote against certifying that vote. So this will not in any way influence the outcome there. But I think it's really interesting that a judge did find that he engaged in insurrection. Yeah. And if a judge found it, perhaps a jury would be willing to find it as well.
Yeah, exactly. I love that Jody made the aw shucks motion with her hand when you said Jack Smith can't use it. That's a legal finding. Shucks. Yep. But so the other thing, Neil Katyal, your friend, said that this is the very worst decision Trump could have gotten, that it could blow up at a later date. I think you kind of just alluded to that, saying this on appeal. Yeah. So what's your take on that?
I think that there's going to be an appeal in this case either way. So whatever the judge found here is not going to be the last word. I think the Colorado Supreme Court will make a decision again as to both of these questions, whether there's sufficient evidence to find engage in insurrection was met, as well as federal officer. And we're seeing different results in different places. Minnesota and Michigan both rejected this claim on legal grounds, saying that a judge is not the proper decision maker as to whether Donald Trump should be on the ballot under this particular part of the 14th Amendment. And instead, Congress has to make a finding. So I think we're going to find a lot of different findings all over the place. I think ultimately this question is destined to go to the Supreme Court. And I think the race is on. How quickly can we get it there? So yeah. I think the best we can hope for is a quick decision by the Colorado Supreme Court, get this to the Supreme Court and get a finding.
Yeah, exactly. So let's talk about what's going to happen today, right? This is Judge Chutkan. What are we deciding on today? I can't keep track. So the gag order in New York, right. They suspended it, and in like 1.2 milliseconds, he started, tweeting about the clerk again and all of that. So today it's Judge Chutkan, right, that's going to be deciding on a gag order.
Yeah, it's actually her order is going to the Court of Appeals today. And in fact, I think they're arguing it right now. This morning, there was to be oral argument in this case. She did enter a limited gag order. She said that Donald Trump could not target any of the witnesses, the parties, the jurors, or court staff in the case. Donald Trump has argued that that is unconstitutional. It's a violation of his First Amendment rights. And that is going before the D.C. Circuit Court of Appeals today. I think she's on very solid legal ground. I know, everybody talks about my First Amendment rights, but they're not absolute. We've probably all heard about reasonable time, place, and manner restrictions. The old, you can't yell fire in a crowded theater.
I was just going to say, isn't that fire in a crowded theater when you're inciting violence?
Yes. And so when it comes to the First Amendment, the test is typically, is there a compelling governmental interest, number one? And then number two, is this order narrowly tailored to achieve that interest? And so that's what the court will be looking at here. The ACLU actually filed a brief in opposition to this, not to the notion of a gag order altogether. They just said that the word targeting was too broad. The judge looked at that again and said, no, I think target means target. Here's the dictionary says to go after. She said to go after for, scorn, derision, or harassment. Yeah, that's what I mean. And so I think I'm good. So I think the worst that's going to happen from this order is maybe they wordsmith it a little bit, or they direct the judge to wordsmith it a little bit. Mm-hmm. But the concept of a gag order in this case, there's a legitimate, compelling governmental interest in, number one, protecting the jury pool from being tainted so that there's a fair trial for both parties, and number two, protecting the safety of witnesses and parties. We've seen Judge Chutkan has been the subject of a death threat. Fani Willis has been the subject of death threats. So it's an absolutely compelling governmental interest. And I think, is this narrowly tailored enough by using the word targeting, or does it need to be more specific? I think that's the worst that's going to happen, is to tinker with the language a bit. But I am confident that that the law should uphold this gag order.
Our friend, former RNC Chair Michael Steele, had some thoughts on it, and he said, put his ass in jail. That's I don't know if that's illegal.
Well, that's the tricky part, right? Is what do you do when he, not if, but when he violates it.
Right.
And I think, you can use, usually you get most ordinary people would get a warning first, maybe a fine, maybe escalating fines. That's what we've seen in New York, right? It was $5,000, then it was $10,000.
Yeah.
But at some point, that is the power the judge has, which is for contempt to jail somebody. And we'll see whether any of these judges has the guts to pull the trigger. I don't know.
Yeah, I mean, this is what Michael said. Put his ass in jail. That's how you end it. That's how it stops. I think we all have this feeling.
That's what would happen to you and me.
Yeah. Are we going to wait till something really awful, more awful, continues to happen? I mean, the last ruling on Judge Chutkan, she pointed the finger at Trump in a blistering order denying a motion to strike mentions of January 6th from his election crimes trial. I swear to God, for lay people, we're like, how can you possibly do a trial and not mention it? Right? In concluding her order, she threw in an aside about Trump's own inflammatory and unsupported accusations against President Biden, referenced the potential for prejudice generated by the defendant. I think it's, again, some of these rulings are just so inexplicable, particularly Judge Cannon's. Can we talk about Judge Cannon? So, again... you've seen Norm Ornstein called for her impeachment. I know that's sort of unlikely. This one, I just wanted to get your take. Who is this? David Kurtz said, obviously she looks like she's going to delay this till after the election. The icing on the cake, Cannon has done what she's done in a way that will make appealing her or seeking her recusal virtually impossible at this stage. Is that true, do you think, Barb?
Yeah, so it's very interesting. She has not done anything, in my view, that's illegal or reversible. But she is exercising her discretion in a way that is very favorable to Donald Trump. Of course, last year, I think she really properly brought some suspicion to herself when she allowed this unprecedented direct challenge to a search warrant. I mean, that's not how it's done.
Right.
You have to wait until a charge is filed and the search fruits are offered as evidence, and that's the point where if you think there's something wrong, you can strike it down. Instead, she allowed this sort of sideshow to go on until she was reversed by the Court of Appeals. So I think that raised everybody's suspicion about her a little bit. And then in this case, what she's done here, I think, is by allowing delay in some of the interim deadlines here, I think she has made it inevitable that that trial date currently set for May is not going to happen. There's classified information in this case, and there's a procedure that you use to deal with classified information to make sure that everybody gets to use the evidence they need, but that evidence is not disclosed to the world in a way that would harm the national security. That process takes a good bit of time to work through. And in this case, the government has asked for a decision by December for Donald Trump to say, this is the universe of classified information I would like to use at my trial. Because you have to do that first before you can then figure out how you're going to deal with it. And what Judge Cannon said is, no, we're not going to talk about that until we get together again in March. Motion denied. So if you're not going to even look at it until March, there's just no way to build that process in within the 2 months between March and May. So she has not delayed the trial yet, but it signals that that's inevitable. So, and then when do you set it, right? Then you've got the trial coming. And so there's a worry that she will sort of incrementally keep moving the goalposts until we get past
Norma Ornstein, I think, argues for her impeachment, knowing it'll go nowhere, but will highlight her conduct. I know Andrew Weissman said Jack Smith has to be weighing whether or when or how to seek her recusal from the Court of Appeals and her removal. You're just saying you don't feel like any of that's going to be likely?
No, I don't think so. I just don't think they've done it. She's done anything egregious enough. I just think, I'm suspicious.
Maybe if we just wait. Just wait for it.
Yeah, I know. How long do you have to wait? I mean, I'm very suspicious of her because of what happened last year. Yeah. And so I think we're all sort of looking, there's confirmation bias where we're looking for good or bad behavior. We're kind of just waiting for the bad behavior. Where is it? Where is it? Ah, there it is. I mean, she hasn't really done anything yet other than say, no, government, I'm not going to make Donald Trump disclose earlier than legally required which classified documents they're going to use. So she's within her discretion to do this, but she's certainly exercising it in a way that is very favorable to Donald Trump and in a way that makes it, I think, inevitable that the trial date will be delayed. But, that alone is not misconduct. That alone is not an impeachable offense. I don't think it's even a basis for recusal, but I think that this demonstrates the power a judge has to manage a case. I don't think you're going to get reversed for making discretionary calls about how you want to manage the docket as long as you're not violating the law. So I think she's going to be smart enough to be very savvy, but whether it's because she favors Donald Trump or just fears handling this case, for the love of God, I don't want to have to decide this case. I'm just going to kick it down the road, let all these other trials go first, and then maybe I will be absolved of my responsibility because Donald Trump will be elected president and he will dismiss this case against himself.
Except
seems like that might be what's going on.
Her keeping this May thing is also pushing Fani Willis's back, right, to August? Yeah. Well,
maybe that's part of the strategy, right? As long as it's on the calendar, you've got to lock up a couple months there for this trial. Yeah. Nothing's going to start until at the end of summer. And so then if she finally says, oh, yeah, we're going to kick it. Oh, but Fani Willis is going in August. So I guess that puts us, and she says that's going to go well into 2025, so I guess we'll go after that one.
I do want to say I think she is the very best member of Donald Trump's defense team, so I'll give her that much. Barb, so thankful for you. Yes. Go Wolverines and all that Thanksgiving football.
Hey, thanks. Go Lions, go Blue. Thanks so much, Stephanie.
All right, love you, Barb.